He's coming to us from the University of Texas Law School, where he's the Jamail Regents Chair in Law and a distinguished teaching professor as well. And most importantly for our purposes today, he will be talking about his book, Academic Freedom, From Professional Norm to First Amendment Right, which just was released. And I'm really pleased, especially because I was on a panel with him on Friday, so we're glad to have him here after his tour of the country presenting on this book. There'll also be copies available, I believe, afterwards for you to purchase and for him to sign. So without further ado, I will turn things over to Professor Rabban. He will speak for about half an hour, and then following that, our very own Paul Brest, who needs no introduction and was once again Dean of the Law School last year, will give a little bit of a response, and then we'll have Q&A until about 2 p.m. So without further ado, thank you so much, Professor Rabban, for being here.
Thank you. Thank you for the introduction. This was the weekend of my 50th Stanford Law School reunion. So it feels right, appropriate to be here at Stanford Law School, and also to have as the commentator the person who taught me criminal law in my first semester of law school. So it's really a nice homecoming. Thanks for doing this. Okay, so I initially intended to write a book about the meaning of academic freedom as a right under the First Amendment. And much of my book tries to differentiate a distinctive First Amendment right of academic freedom from general First Amendment rights of free speech. My research convinced me that American courts have clearly recognized a First Amendment right of academic freedom, but as judges themselves have often complained, they have not elaborated the meaning of that right or its relationship to the First Amendment generally. In contrast, the 1915 Declaration of the American Association of University Professors, the AAUP I'll call it from now on, contains what remains the most influential justification and the most convincing justification of academic freedom, an analysis of its scope. The current regulations of most colleges and universities derive from the analysis of academic freedom in the 1915 Declaration over a century ago. And I realized in doing my research, in the course of my research, that the analysis of academic freedom in the 1915 Declaration could apply to the analysis of academic freedom as a First Amendment right. The production and dissemination of knowledge, the societal interest that the 1915 Declaration recognized as the justification for academic freedom, is also a fundamental First Amendment interest, recognized by the judiciary in numerous contexts, not just in the university one. So I decided to analyze the 1915 Declaration's treatment of academic freedom in the first chapter of my book. And my attention to the 1915 Declaration is reflected in the subtitle. I'll do a little show and tell. From professional norm to First Amendment right. And the professional norm part is the analysis of academic freedom in the 1915 Declaration. I also draw on further development of the concept of academic freedom within the profession throughout my book, while formulating my own theory of academic freedom as a First Amendment right. So the 1915 Declaration tied its defense of academic freedom to its conception of the professor's function. It's a functional definition of academic freedom. The pursuit and dissemination of knowledge based on expertise gained through lengthy study. And the 1915 Declaration stressed that professors cannot perform this societally valuable function if people without academic expertise are able to punish them for expressing their expert views. The 1915 Declaration recognized that if speech by professors does not meet academic standards, it is not the expert academic expression that contributes to the production and dissemination of knowledge, and therefore does not merit the protection of academic freedom. But it insisted that only other professors are competent to determine whether academic speech meets academic standards. Involvement by others, it warned, would inevitably raise suspicion that the decision was based on inappropriate grounds, including grounds that might violate academic freedom. So peer review became a key element of the system of academic freedom as a professional norm. In a move that was extremely controversial at the time, and that remains controversial today, the 1915 Declaration defined academic freedom to include political expression off campus by professors unrelated to their professional expertise. That extension was extremely controversial. And the 1915 Declaration itself did not spend much time elaborating why it extended academic freedom to general political expression. Perhaps because the people who wrote the 1915 Declaration were themselves deeply divided about whether that extension was justified. And I just want to give you a sense of that debate among the founders of the AAUP and the framers of the 1915 Declaration. One finds this in archives, historians here. You learn a lot in archives that you don't see in published documents. And that's certainly true with respect to this extension of academic freedom to cover general political speech in the 1915 Declaration. So one of the authors of the 1915 Declaration, John Wigmore, the famous professor of evidence at Northwestern, argued that academic freedom should only extend to off-campus speech by a professor related to the professor's academic expertise, but it should not cover general political expression unrelated to a professor's expertise. Now, Wigmore acknowledged that occasionally it might be difficult to determine the line between speaking with an expertise and speaking about general political matters, but he thought in most circumstances the boundary between the academic and the general political is clear. So that's Wigmore. Another author, Roscoe Pound, soon to be dean of Harvard Law School, argued by contrast that the line between the academic and the political is often uncertain. And he used as his example a professor of Greek. Pound said that it is plausible for a professor of Greek to argue that from his study of Thucydides, he had learned enough about revolutions and counter-revolutions described and analyzed by Thucydides to analyze revolutions and counter-revolutions in the contemporary period, in the 20th century. And the protection of academic freedom should extend that far. Okay, another framer, Arthur Lovejoy, famous historian of ideas, worried that the restriction of academic freedom to a professor's expertise would allow trustees to invoke the general political expression of a professor as a pretext to punish the professor for academic expression. And that was dangerous. Okay, pragmatic considerations may have largely accounted for the 1915 Declaration's extension, controversial, of academic freedom to general political expression. The 1915 Declaration was written at the end of the first year of existence of the AAUP. And during that year, the AAUP had investigated 5 complaints at different universities by professors who said they were fired for exercising their academic freedom. And all 5 of those investigations uncovered that these professors were fired, at least in part, for their general political expression unrelated to their academic expertise. And at that time, neither the First Amendment nor the law of contracts protected those professors. So as a leading historian of academic freedom, Walter Metzger wrote, and I think this is very convincing. I want to quote Metzger because I think he phrases it very well. Metzger said the 1915 Declaration, quote, stretched the cloth of protection over an area in which academics proved to be most exposed, right? The cloth of protection, academic freedom, over the area where academics were most exposed, general political expression. Okay, soon after the publication of the 1915 Declaration, the president of Harvard provided another perspective on the relationship between academic freedom and general political expression. He maintained that the right of a professor to express views unrelated to his expertise is not a question of academic freedom in its true sense, but of the personal liberty of the citizen. And to illustrate, he pointed out that a professor of astronomy, unlike a professor of economics, has no particular expertise to speak about the protective tariff. And on this issue, the professor of astronomy is no different than any other citizen, whereas the professor of economics would be because of his expertise. But the president of Harvard, Lowell at the time, added that even when speaking as a citizen unrelated to academic expertise, a professor should not be disciplined by a university, even if that political speech might harm the university's interests. And Lowell wrote, here I'm quoting again, if a university restrains the political expression of professors, it thereby assumes responsibility for what it permits them to say. And he believed that this is a responsibility the university would be very unwise in assuming. Rather, Lowell said, a university should let the off-campus political expression of professors unrelated to their expertise be dealt with by the same laws that apply to all citizens, but not dealt with by the university. And Lowell practiced what he preached. He resisted the threat of an alumnus who had made a $10 million bequest to Harvard. $10 million was real money in 1917. The alumnus threatened to withdraw the bequest unless Lowell fired a history professor of German-American ancestry who opposed American involvement in World War I. And Lowell refused to do so because that was general political speech, not Harvard's business. Okay, I'm looking for water, but I don't see any. I'll take one, thank you. My sip provides a segue to my next topic, which is the relationship between academic freedom and the First Amendment in judicial decisions, moving from the professional norm to the First Amendment right. So in a case called Sweezy versus New Hampshire in 1957, the Supreme Court, for the first time, identified academic freedom as a First Amendment right, contrasting it with political expression. So it was only in 1957 that the Supreme Court incorporated academic freedom as a First Amendment right. And in a case called Kieshian v. Board of Regents 10 years later, the Supreme Court called academic freedom, quote unquote, a special concern of the First Amendment, a special concern of the First Amendment. Hundreds of lower court cases have cited this language. Academic freedom is a special concern of the First Amendment, but they have not elaborated how academic freedom is a special concern of the First Amendment, or its relationship to the general First Amendment right of free speech. So while courts have clearly recognized academic freedom as a First Amendment right, I don't think that's a debatable point anymore. Academic freedom is a First Amendment right, but it is unclear what it means. And perhaps because of this lack of clarity, decisions have reached inconsistent results about its coverage. Okay, in the legal decisions, some courts have said that academic freedom means the application of general First Amendment law with particular force. No elaboration, but that's their claim. Other decisions have said that academic freedom requires modification of general First Amendment principles in the university context, and some have asserted that academic freedom is a distinctive First Amendment right, differentiated from general First Amendment doctrines, but they don't specify how it is distinctive. Okay, this may be too elementary for a Stanford Law School audience, but I think the point is so important, I want to spend just a couple of minutes emphasizing, of course, that the First Amendment applies only to actions by the state. A lot of people forget that, even lawyers. I have a First Amendment right, not against everybody, against the state. Okay, so legislatures, executive branches of government are state actors, as are public universities, but private universities are not. So, First Amendment academic freedom applies to legislative and executive actions that affect professors and universities, including private universities and the professors who work in them. And First Amendment academic freedom applies to disputes between professors and administrators and trustees at public universities. But the First Amendment right of academic freedom does not apply to disputes within private universities, like this one. So a professor at a private university can invoke the First Amendment right of academic freedom to challenge legislation and regulation. And a case at Stanford I could discuss later did just that. But a professor at a private university cannot challenge the actions of administrators and trustees at that university. But it is also important to point out that many private universities voluntarily accept for themselves the requirements the First Amendment imposes on public universities. And I think this is mainly because private universities do not want to be perceived as offering less protection for free speech or academic freedom than public universities. I want to give an example from 50 years ago when I was at Stanford. Paul, you probably know a lot more about the Bruce Franklin case than I do. But when I was a law student at Stanford, the administration brought dismissal charges against an eminent tenured professor of English, expert in Melville, for allegedly inciting to riot on White Plaza. You see that computation center over there? It's part of the war machine. We've got to shut it down. It's not enough just to sit and stand and protest. And the argument was, I don't know the underlying fact, but the argument was, and the finding by the faculty review board was, about 20 minutes later, students entered the computation center, not Franklin himself, he was at distance, and trashed it. Was that incitement to riot? That was the issue in the case. But the Stanford administration told the faculty hearing committee, apply the First Amendment. They didn't have to, but they did. Okay, ever since the initial decisions recognizing academic freedom as a First Amendment right, which protected teaching about Marxism from investigation and regulation by the state, many cases have maintained that the First Amendment right of academic freedom covers the content of academic speech. In a much more recent case, for example, a judge held that this right of First Amendment academic freedom covers the claim of a professor of obstetrics at a public university that his department chair fired him for advocating vaginal delivery rather than unnecessary cesarean procedures. At least where the views of a professor are well within the range of accepted academic opinion, the judge stressed, they should be protected by the First Amendment right of academic freedom. So this content is very different than the content of the Cold War cases, but it illustrates the First Amendment right of academic freedom protects the content of academic speech. Many decisions have extended the First Amendment right of academic freedom to cover pedagogical decisions by professors in class. So one interesting case involved a professor who taught a course called Language and Social Constructivism. That's a course that would not have been taught when I was in college, but was taught decades later. And in that class, the professor asked students to suggest words used in the interest of the dominant culture to marginalize minorities and other oppressed groups. And student suggestions of those words included epithets that insulted homosexuals, blacks, and women. And the professor was disciplined for that student response. In protecting the academic freedom of the professor to conduct that exercise, including yielding these epithets, the judge emphasized that the words elicited were quote unquote germane to the subject matter of the course and were not used in a gratuitously abusive manner. There's an example of extending academic freedom to pedagogical decisions beyond the content of research or teaching. Now, a lot of lower court decisions have limited academic freedom as a First Amendment right to the content of academic speech. That's all. So on this basis, a court rejected a challenge by professors to a state law that made the use of aborted fetal tissue in research a felony. One of the professors who was subject to that law had used mixed cell cultures derived from aborted fetal tissue to study Alzheimer's disease, for example. And writing for the court, Judge Easterbrook, former law professor at the University of Chicago, called the professor's academic freedom claim, quote unquote, a non-starter. Not even simply rejecting it, it's a non-starter. So Easterbrook acknowledged that the use of fetal tissue in research could lead to speech, but he emphasized that a desire to obtain input into speech does not convert regulation of conduct into regulation of speech. And Easterbrook stressed that the law in no way prevented the professors from saying, writing, or teaching anything, including to results obtained from the use of aborted fetal tissue in research in states and nations that allowed it. Okay, other decisions have protected academic speech and research beyond the content of speech. So quite a number of decisions have protected the confidentiality of professors' research material, pointing out that people might not be willing to participate in research without guarantees of confidentiality. And cases illustrating this point, where there was a First Amendment right of academic freedom recognized in keeping research material confidential. One was a case at Boston College. Has anybody read the book Say Nothing? It's about the IRA was, I think it was on the New York Times bestseller list. Anyway, it dealt with this matter. And researchers at Boston College promised confidentiality to members of the IRA they were interviewing, who were scared that if their names were revealed, they could be subject to violence, perhaps killed. In another case, the concern was about the confidentiality of patient records used in medical research. And in both these cases, the courts recognized a First Amendment academic freedom issue in protecting confidentiality. Okay, beyond the core areas of scholarship and teaching, some courts have extended academic freedom to protect speech by professors about university affairs, such as opposition to a university's foreign exchange program, or a proposal for a revised curriculum in a communications school that would redress the perceived imbalance the professors saw between theoretical and practical courses in the communications school. A very few cases have extended the First Amendment right of academic freedom to general political speech, but very few have. Most of those cases are decided on First Amendment free speech grounds without referring to academic freedom. Okay, I now want to raise two factors that complicate the analysis of academic freedom as a First Amendment right of professors. Okay. In many decisions, courts do not refer to the First Amendment right of academic freedom when it clearly applies. So while academic freedom has been extensively recognized as a First Amendment right, it has also been extensively ignored. For example, in cases challenging state laws prohibiting the teaching of evolution or requiring the teaching of quote-unquote creation science, the Supreme Court did not address academic freedom arguments raised by the litigants and addressed by the lower courts. Instead, the Supreme Court held that these laws constituted an unconstitutional government establishment of religion, which is plausible, but it doesn't deal with the academic freedom arguments that are clearly there. So the First Amendment right of academic freedom has not been deeply established, I feel, even though it's been frequently recognized. Okay, also, and this is worse from my perspective, courts often apply areas of First Amendment law instead of the First Amendment law of academic freedom in ways that deny claims that should be protected by academic freedom. And I want to give two examples of this from the First Amendment law governing public employees, sometimes called employee speech jurisprudence. And that area of law is based on the principle that the state as employer has greater interest in regulating the speech of its employees than the state as sovereign has in regulating the speech of citizens. So, to be protected by the First Amendment, general law of free speech, speech by a public employee must be about a matter of, quote unquote, public concern. And many courts have found that academic speech by professors is not about a matter of public concern. For example, abstract theorizing, who cares? Criticism of administrators designed to make the university better. That's a private concern within universities, not a matter of public concern. Claims by professors that universities deny them tenure based on violations of academic freedom. Private concern. No mention of academic freedom. Other courts, by contrast, have defined, quote unquote, matters of public concern more broadly to include academic speech that contributes to scholarship and teaching. So the application of this law of employee speech jurisprudence leads to the denial of claims that would clearly be protected by First Amendment academic freedom. Second, last point about employee speech jurisprudence, speech by public employees, quote unquote, pursuant to their official duties, is not protected by the First Amendment. What are the most basic official duties of professors? I would say scholarship and teaching, right? If this analysis were applied to professors, it would undermine the right of First Amendment academic freedom. So I was general counsel of the AAUP when the case raising the issue of whether speech pursuant to official duties is or isn't protected by the First Amendment. The case involved an assistant district attorney. But when I read the grant of cert, I saw the issue and I worried that the court would adopt this official duties standard and apply it to professors. I don't know whether it was because of our brief, I like to think so, but in any event, Justice Souter in his dissent made this point, and more importantly, in the majority opinion, 5-4, Justice Kennedy acknowledged that issues are raised by the scholarship and teaching of professors that maybe should not be covered by the official duties test, but those issues are not raised in this case. We'll save them for another day. This was about 15 years ago. Since that decision, some lower courts have recognized what they call an academic freedom exception to the official duties test, but other courts have not and have applied the official duties test to deny protection for the scholarship and teaching of professors. I have more to say, but I think time is running out, Bernie.
Yes, I think we'll switch to Paul and then we'll...
Right. So I could talk more about my own theory of what First Amendment academic freedom should mean. I could talk about the extension of academic freedom beyond individuals to institutions generally, but that can come up in our conversation later. So thanks for your attention. I'm eager to hear from Paul.
So my job is to complicate things further as a commentator. But before I do that, let me just say that this 300-page book is just a very, very important contribution to the field. It's comprehensive. You could think of it as a brief for making the First Amendment applicable, for incorporating academic freedom in the First Amendment. It's a magnificent brief. One minor change, because you haven't been in California for a while, is at the time the Bruce Franklin case was tried, it was the university's decision to subject itself to First Amendment rules. Subsequently, as a result of a speech code developed by Tom Gray, who you know well, the California legislature passed something called the Leonard Law, named after the legislator who proposed it. And the Leonard Law makes the First Amendment fully applicable to all private universities in California. So Stanford is, in effect, bound by the First Amendment through the Leonard Law. So David makes a critically important distinction early in the book, which is the difference between free speech as protected by the First Amendment in general and academic freedom. Free speech is individual and egalitarian. Every one of us has a right to free speech. Sometimes it may be for the search for truth. John Stuart Mill thought it was both a matter of individual liberty, but in the long run led to truth when all viewpoints could be heard. Sometimes just for pure expression or to annoy somebody else. Academic freedom is not an individual right. It's really an institutional it's meritocratic, right? We'll come back to this in a moment, but the whole peer review process is a meritocratic constraint. It's both the source of and a constraint on academic freedom. It's communitarian. And its goal is the search for the truth in research in the classroom. So, as David mentions, the Supreme Court, sometimes in majority opinions, more often in concurring opinions, has hinted that the First Amendment protects academic freedom, but it has actually never made that decision. And the barrier which we need to overcome, which David needs to overcome, is a case he alluded to. It's called Garcetti versus Ceballos, in which the court held that a public employer, in this case I think it was the city of Los Angeles, could discipline an employee for making statements in the course of his work. Not extracurricular statements, extramural statements, but statements in the pursuit of his duty. So the question then is, to what extent can faculty at public institutions, let's focus on public institutions and Stanford, can claim that same right? It's being tested in at least two current and really interesting cases. One, Purnell versus Florida Board of Governors. The State Board of Governors in Florida, in effect, imposed what Florida called the Anti-Woke Act, which forbids faculty members at public institutions from teaching certain concepts. I mean, their notion, it all goes under the banner of critical race theory. And faculty and some students, but let's focus on the faculty, challenged the law as inhibiting their academic freedom. There is a very extensive, and I think well, I'm persuaded by it, I'm sure David is persuaded by it, opinion by a district court Judge Walker that argues that the First Amendment protects the faculty member's academic freedom in that case. Sort of the mirror image, the governing board of California community colleges, in effect, imposed a woke ideology on its faculty. And I don't know, I think we have one member of the audience, one student who probably knows what the current state of the case is. It's called Paul's Guard versus Christian, but this was challenged really for the same reason, that Florida cannot impose anti-woke ideology on the faculty, nor can California community colleges impose a pro-woke ideology. But the fundamental question is this. Let's assume, and I think this is right, that the state, as a state, has a right to take positions on political and social issues. We've seen in the last couple of weeks that Governor DeSantis in Florida has taken a position about an anti-abortion position. And if you think about it, I mean, state policies all take positions on social issues. So it would be at least peculiar if the state could not take public positions and articulate public positions. But in that case, why doesn't the state have a right, when it creates a state university, a state college, to say this college should adopt our public positions, right? The state has a right to say this college should focus on agricultural technology, right? I mean, Davis started as an ag college. It can create community colleges and create higher colleges. It can prescribe, to some extent, it can prescribe the curriculum. Why shouldn't it create an institution that fits the state's ideology? David's argument, which is that the very nature of an institution of higher education, and maybe that's the word higher comes in, as distinguished maybe from K through 12, that its very nature is a search for truth that would be inhibited if the state required its faculty to take ideological positions or prohibited some ideological positions. But where does that nature come from? I mean, it's not as if this is a Platonic, maybe it is the Platonic ideal of the university, but why can't the state sacrifice the Platonic ideal? Why can't a state say, we think the search for truth is good, but within some boundaries. It's our institution, we have the decision to create it or not. An analogy in private institutions is there are some very great and renowned private religious institutions that have a broad a broad concept, broad protection of academic freedom, except for certain things, typically involving abortion or gay rights, in which the university takes a position. So why can't a state take a position saying, we'll create this institution, but it needs to fit within our bounds? That's one question to make life a little bit difficult for David, not that he doesn't have great responses. The second one is a peculiarity, a tension between peer review on the one hand and a fundamental, kind of the strongest prohibition of the First Amendment, which is against discrimination based on viewpoint, right? So state entities, including universities, as we've seen in the last year or so, have broad power to decide what the appropriate time, place, and manner of protests and other expression are. They can even make some distinctions with respect to the content, but what's really anathema to the First Amendment is discrimination based on viewpoint. And yet the very nature of peer review means that your peers in making a appointments decision or promotion decision at some universities, not Stanford, but some universities actually deciding on a faculty member's permissible syllabus, can take viewpoint in consideration. A decision to hire somebody because the faculty believe their views of scholarship in this area comport with what they think are good, and not hire somebody because they think those views are bad, is the essence of peer review, and it is the essence of viewpoint discrimination. So that's my second. I'll just end with a third kind of little problem, which is, how does academic freedom, how does the First Amendment and academic freedom actually, how do they deal with the decisions involving the internal governance of the university, and particularly the allocation of decision-making authority? So the essence of peer review is a department has expertise in an area, and it can make hiring, promotion, and firing decisions. And at the other extreme, we think the Board of Trustees cannot. Maybe even the Faculty Senate. We've had some issues this year kind of involving similar cases. Maybe in the Faculty Senate can't, because the Faculty Senate are not experts in one field. They represent faculty from throughout the field. And it's a complicated question, right? At Stanford, an appointment in the School of Humanities and Sciences is made initially by or recommendation is made by the department. It goes through a school-wide appointments and promotion committee. It then goes to a university-wide committee, which does represent the faculty from across the university, the advisory board. And I think that's the end of the process. I think the trustees may or may not have to approve it, but it's pretty rubber stamped. At Harvard, the president of the university actually has the last word for every appointment. So these are complicated questions. To what extent, the peer review process, which is core to academic freedom, can flourish. Maybe it can be argued that these other levels are simply a way of maintaining the what you might call the integrity of the peer review process. But once the First Amendment applies to the internal governance of the university, as it would under David's view, then all of these questions of internal governance become First Amendment questions as well as academic freedom. So none of these comments is meant to undercut the brilliant and, to my mind, often persuasive arguments that David makes, but it does raise some complications.
Thanks.
So we'll go ahead and if you want to respond to anything that Paul mentioned, David, you're welcome to. Otherwise, we can hear from the audience.
We have till 1?
Until 2, yeah.
Oh, yes, that's 2, right. I think I can respond briefly in 2 or 3 minutes, so why don't I try to do that to the 3 points Paul made. On the definition of a university, it's almost a sociological point, I think. A university has a certain function, so maybe it is a Platonic ideal of a university. There's a well understood function of a university, and if an institution calls itself a university, it should be committed to that function. That is, you could say, the pursuit of truth, the pursuit of knowledge. That's what a university does. Under the professional concept of academic freedom, take religious universities, but it would also apply to private universities that have maybe different or other goals. The 1915 Declaration makes a distinction between what it calls ordinary institutions of higher learning, called universities, and quote-unquote proprietary institutions devoted to the propagation of a particular idea. And for the 1915 Declaration, and for me, proprietary institutions are not universities. Now, a religious university, based on the religious provisions of the First Amendment, can be proprietary with respect to religion. And the AUP definition of proprietary universities says that religious universities can do that, though most universities don't very much. Religious universities don't limit the academic freedom of their professors, but if they do, that's okay as long as they're clear, they're proprietary with respect to religion. So that's on the defining a university point. On the viewpoint discrimination point, so I would say this is why we need the First Amendment right of academic freedom as a distinctive right. Because the general First Amendment law that is so hostile to discriminating on the basis of viewpoint, understandably so, doesn't cover legitimate academic decisions based on the academic viewpoint of professors that may not meet academic standards. And universities ought to be able to discriminate on the basis of viewpoint or content when the basis has to do with academic quality. I would say that's why we need a distinctive right of First Amendment academic freedom and not just apply the general law of First Amendment to universities. On the third point of governance, even under the professional definition of academic freedom, there's a role for administrative and trustee review as a check on abuses of peer review by faculty. That's appropriate. And it's also appropriate in law. If the peer review committee, for example, doesn't itself follow professional standards in conducting peer review, bases a decision because someone is a woman or a minority or has expressed controversial views about a matter. So I think the First Amendment right of academic freedom could incorporate the kind of structure of university governance that already exists. And in particular, this is a point I argue, novel, maybe controversial. I think judges should order peer review of academic disputes if they have not already occurred, rather than, as they often do, just defer to the decisions of administrators, but also as a First Amendment matter, if the President, Board of Trustees can provide compelling reasons for overturning the peer review judgment, and sometimes there are compelling reasons, the First Amendment ought to recognize that that is legitimate under First Amendment law. So I'll stop there.
So one before Bernie opens it up to questions, I'm sure you have many. Just on the first one, the name can't be it. That is, suppose instead of trying to take over New College in Florida, the Florida legislature created a new institution called a partial versity. It had many of the aspects of university, except there are certain areas where it must teach certain things or may not teach. The name of the thing can't be dispositive.
I agree with that.
Okay.
Okay, so yes, first question.
So I like this. I've enjoyed this. Thank you very much, Professor David. I like this question around universities because if you think about what is the purpose of a university, right? and then you go back to this First Amendment right of academic freedom. Well, if the purpose of a university is a much bigger, for the greater good of the community, then I think you could come to the conclusion that there should be this academic freedom that's tied into the First Amendment because the university itself is a part of the larger community. I don't know if anyone's made that argument, but that's how I'm seeing this.
Well, in the 1915 Declaration, particularly, but sometimes in cases, in the 1915 Declaration, there's a recognition that the production and dissemination of knowledge is a societal good. And it's for the good of society that professors have academic freedom that allows them to produce and disseminate knowledge and not be fired for doing so if others without academic expertise disagree with their views. So yes, there's a great emphasis, which I probably should have stressed more, on the societal value of this special protection of professors. Yes.
And I think it goes back to what Paul said about the kind of communal value of academic freedom as opposed to, say, the individual right of speech as well.
Right, but just to follow up on that very insightful question, about 10 years ago, Jonathan Haidt, who teaches psychology at NYU, but is also the founder of Heterodox Academy, gave a talk in effect saying, you know, an institution can choose between being truth you or social justice you. His implication was that for everybody in this room, it would be truth you. But there's nothing, I think, in the concept of higher education to say that an institution couldn't be social justice you as well.
And I would say, I don't know if it's adding or disagreeing, it could be social justice you as long as being social justice you does not interfere with its being truth you. Sometimes social justice you can supplement truth you. Sometimes it can interfere with it. And when that happens, I believe that should be considered a First Amendment violation of academic freedom.
And so maybe I should have started this out with the Constitution, right? And all men being created equal, like these or even the Declaration, we hold these truths to be self-evident. That's from a religious perspective, right? So what we were, that was social justice, if you think about it. So I was just thinking about it from this historical, right, the historicity of our founding documents, if that makes sense. And so
Yeah, but there's a lot in the Constitution that's supposed to protect efforts to obtain social justice, but that's not what universities, in my view, fundamentally are about.
true. Thank you.
Jack.
Okay, so David, I have to say that part of this reminds me of your book. It's from bad,
Which one? Which one?
Free Speech, the Forgotten
Yeah, I
Years.
know.
You know, from bad tendency to clear and present danger.
Yeah.
But that's. Well, I have a different question, and I think it's predicated in part on the Franklin case, which I've heard. It was before my time, but I've certainly heard colleagues discuss it. And the current situation on university campuses. And I think the relationship between the free speech clause on the one hand and the petition assembly clause on the other. You want to have a more general First Amendment canopy or whatever umbrella to think about these issues. So it seems to be the situation on campuses today, particularly in the aftermath of October 7th, that's a fact situation somewhat different from what involves Franklin. So Franklin was urging students to undertake an action directed against, university property and so on. We had something similar at Stanford when a group of students occupied the president's office back in the spring. But there are other issues where faculty are intervening on behalf of students whose behavior might be regarded as being in some sense problematic to the well-being of the community. So, I mean, I think this happened at Princeton. I think it certainly happened at UCLA. I think it actually is, talking about this, Paul, I think it may have happened to my alma mater, Haverford, and, in events that have taken place over the last year. So what, if you're, hopefully, if you're following the logic of what I'm trying to get here, if you're not, I'll try to explain it more, but I'm trying to think about how you think about free speech and the right of people peacefully assemble and petition for the redress of grievances in the context of university life today with the kind of situation universities and colleges have been confronting over the past year. Did that make sense? I hope.
Let's see. So my very brief answer is that most issues that have arisen since October 7th, not all, but most, have to do with free speech, freedom of assembly. They're not academic freedom issues, most of them. Every now and then it's a professor who has expertise in the Middle East making a comment. That's academic freedom. But most of these other issues, they're important, they're controversial, I have views about them, but they're views based on my understanding of the general First Amendment rights of free speech and assembly, not about First Amendment right of academic freedom.
Well, that's a direct answer. Yeah, good.
Good.
Yeah.
Jed.
Great, thanks so much. So I'm curious about how much your concept of academic freedom in its implementation needs to account for some of the sort of prophylactic concerns that we worry about in other areas of First Amendment law. So we might, as an abstract matter, conceptually define academic freedom in the way that you've provided, and then we might, as an abstract matter, say this type of speech should be protected, or this type of activity should be protected, and this type shouldn't. But in its implementation, we sometimes worry about chilling effects, or we sometimes worry about, so one of the things you brought up at the beginning of the talk was retaliation. And in some areas of First Amendment law, we therefore go a step further, and we say, well, not only in the abstract are we going to protect this type of speech because the Constitution protects it, but we're going to go a step beyond and give a kind of buffer space for that sort of speech. So I guess my question is twofold. One is just as somebody who has more experience with these issues, to what extent are those concerns real? That is like that retaliation is actually happening in ways that would underprotect this sort of academic freedom that you're talking about. Like, to what extent are universities actually protectually disciplining people for, you know, failure to go through the proper trainings or not showing up to work on time or whatever it is that's not directly about the things that are covered by academic freedom, but are nonetheless motivated by things that are within the realm of academic freedom. And then the second question is like, what do we do about it? Because we don't want to give professors immunity for all of their conduct, and yet any of their conduct that is misfeasance could be, in theory, disciplined on the basis of pretext as opposed to on the basis of a genuine concern about that misfeasance. So I'm curious how you would balance that.
This is responsive. You'll tell me if it isn't. So I worked as a staff lawyer for the American Association of University Professors for almost 7 years. So I heard a lot of academic freedom claims, some plausible, some not, some pretextual. And then I was, general counsel. I was chair of its academic freedom committee. People call me all the time. So I'm aware of what's been going on. And I would say there's quite a bit of pretextual citation of factors unrelated to academic freedom as the basis for actually disciplining for speech that should be protected by academic freedom. What do you do about that? One thing I think you don't do about that is what Lovejoy wanted, which was to extend the protection of academic freedom to general political speech to avoid letting trustees use general political speech as a pretext to fire a professor for academic speech, and they don't want to admit that's the reason. And there's all kinds of other pretextual usage. But to extend academic freedom prophylactically to general political expression unrelated to academic expertise, to me, undermines the basic justification for academic freedom as a distinctive First Amendment right. In a lot of judicial decisions, one sees language where judges are concerned about giving special treatment to professors. Isn't the First Amendment an equal right of all citizens? This has to do with the comment Paul was making about differentiating academic freedom as communitarian and meritocratic as opposed to egalitarian and individualistic. So I just think the conceptual damage and the loss to possible acceptance of a distinctive theory of academic freedom by overextension for understandable prophylactic reasons is not a good idea. What should be done, I think, and judges can do this, is to look for pretexts and call them out. You see this a lot in judicial review of Title VII cases involving higher education. The professor claims she was not given tenure based on her sex. The university says, Judge, for you to decide this question is a violation of our institutional academic freedom. We made this decision based on academic grounds. Well, there are ways for judges to decide whether reasons are pretextual. Really, it's not based on sex. She wrote 3 books. The 3 men who got tenure last year only wrote 1. I mean, there's lots of stuff that indicates pretext. I think that's a better way of getting at this than prophylactic overextension that undermines the credibility of the concept. I hope that's responsive.
Yes.
Hi, just a quick question on the issue of the peer review, essentially, that you're advocating for, and how that would look. A couple concerns come to mind for me. One of those is the evolution of academic disciplines over history, being a little instructive with this. Like, you look at the departments of phrenology that existed briefly at universities around the world, and quickly had their entire subject debunked. Or then I think also the other concern with that is fields where perhaps practitioners may be generating even more knowledge than professors are, and professors may actually maybe not be as knowledgeable on the public issues as people practicing in that field. So my question just becomes, how do you structure the peer review such that you're rewarding the search for truth that you describe as being the university's aim, and not just sort of academic inertia?
Well, I'm sure Paul has a response to this based on his experience as a dean. I'll give you my take. You're absolutely right that what's considered legitimate academic knowledge in a field changes over time. There was an example of a Nobel laureate, I think in medicine, who taught at the University of Pennsylvania, this was last year, who didn't get tenure because the research that ultimately won her the Nobel Prize 20 years later was considered inadequate. Okay, so that happens. Concepts within fields change. I think into the 1970s, others may know this for sure, but I'm pretty sure the official handbooks of the American Psychiatric Association and the American Psychological Association listed homosexuality as a disease. I think today that view would be considered the equivalent of the earth is flat. This is just to show things change. What do you do about it? In my view, what you don't do about it is give decision-making power to people who don't have any expertise at all. I think, on this I'm optimistic. I think most professors, they basically get it, right? They understand that ideas can be controversial. And most people, most of the time, I believe, bend over backwards to include within the university views with which they deeply disagree, but not always. And now, departments can be self-correcting over time, as the Nobel Prize illustration shows. These are inevitable flaws in the peer review process. Kind of self-awareness, checks on this by the administration and maybe the courts is a possible, not solution, but amelioration. And as they say, 2 cheers for democracy, 2 cheers for peer review, show me something better. I just think it's the best that exists, and being aware of its potential flaws helps avoid abuses.
Did you want to add anything there too?
No.
Okay. All right. Great. Any other questions? I think we have time for one more.
There's one.
Great.
I have a question at the end.
Oh, perfect.
How about your thing on critical legal studies from the 80s?
Dave, great talk. Thank you. I have a question. You allude to some of the religious schools, affiliated schools, but didn't really get into discussing how that can be an exception first of all, what teachers can teach in a like a Biola University in terms of evolution or abortion or stuff. And then the flip side is if you're a student there, can that school, and this would be probably more of a First Amendment issue rather than an academic freedom issue, could a school like that then kick out a student or refuse to give them a diploma because they had an abortion or they, for whatever reason?
I don't really have an expert answer to your last question. Just to illustrate the problems that arise at religious universities, which I think you were asking about, Josh, there was a case involving someone named Father Curran at Catholic University of America around 1980. Now, Father Curran taught in the theology school of Catholic University, not even religious studies, theology. And he came to the conclusion that the right to abortion is consistent with Catholic theology. And he taught that view in the theology school of Catholic University. And he was fired for that. And he sued as a contract law, private university. And in negotiations after he brought suit, I met the lawyer who handled this case for Catholic University. It was very interesting. He went to meet with the head of Catholic doctrine at the Vatican, who later became Pope, right? So for this guy, the lawyer was a Catholic, it was like the thrill of his life. And they were willing at the Vatican to say to Father Curran, you can teach at Catholic University in the sociology department, you can even teach in the religious studies department. You cannot teach in the theology school because the purpose of the theology school is to teach Catholic theology, and your view of it is wrong. The notion that religious institutions can exempt themselves from the requirements of academic freedom, if they're clear about doing so, is generally accepted. And the judge found for Catholic University in this case. So there's just an example of what can happen in a Catholic university.
So maybe I'll close with the question that we've been discussing a lot at Stanford, but we've seen it nationwide. And nationally, it's often called the issue of institutional neutrality, which comes from the Chicago principles. Stanford's academic freedom statement has, in the flip side, it prohibits institutional orthodoxy. And Bernie chaired a very important committee whose report was accepted by the Faculty Senate of the administration, which in effect prohibits making institutional statements except in rare circumstances. I think this is an example where violating, to bring it to Stanford, violating our prohibition of institutional orthodoxy is a violation of academic freedom. And the notion is that when the university administration takes a stance on positions, it will inhibit faculty from taking stances that disagree. I think that's a violation of academic freedom. I don't think the First Amendment has anything to say about it. What do you think?
Assuming it was at a public university taking
That's
this position?
Right. So the University of Michigan takes a position on Black Lives Matter or takes a position on Israel and Palestine. Under these principles, it violates academic freedom. I don't think there's a First Amendment claim by anybody.
So I'm less certain than you are that there's a violation of academic freedom apart from the First Amendment. This is the prophylactic effect that Judd was referring to. Individuals can take different positions from the university.
No, we're talking about the university administration taking this position.
Yes, that doesn't prevent
Right.
a professor from taking a different position. Yes, the professor might be inhibited, but to me, it may be a violation of academic freedom. In the scope of things, it's a pretty small one, given that people are fired for, core positions on academic matters. So yes, maybe it's a violation of academic freedom, not so important. But to the extent it is a violation of academic freedom, I don't see why it shouldn't be covered by the First Amendment, right of academic freedom. To me, the First Amendment protects academic freedom.
So with that clear statement,
Yes, that's right.
let's join me in thanking David Rabban and Paul Brest.
Thank you.